What can you learn from Jay Cutler's recent DUI arrest? I'm attorney Danny Izquierdo of the Izquierdo Law Firm. And whenever we do these videos after somebody famous or quasi-famous from the world of sports and entertainment happens to get arrested, there are always lessons that can be learned. In the case of former Bears and Dolphins quarterback Jay Cutler, who was recently arrested for a couple of things, among them DUI, possession of a firearm while under the influence, and he also attempted to bribe another motorist with whom he was involved in an accident and flee the scene once that motorist did not accept his, let's call it, offer and compromise to kind of just handle it amongst themselves rather than getting the police involved. Let's start with the DUI. At the scene, once officers got there, Cutler immediately refused to take field sobriety test and breath test. Now, in Tennessee, they were able to obtain a warrant to then take Cutler's blood. So they're going to prove that he was intoxicated or impaired, presumably by whatever that blood draw shows. Now, in Florida, there could be such a thing as forced or compelled blood draws. However, that's typically limited to cases where there's serious bodily injury or death. Okay, it seems like Tennessee may have slightly stricter laws here in that they simply just went and got a warrant upon Cutler's refusal. On the DUI front, he's also charged with an implied consent violation. The implied consent warning is what the officer reads to you. In Florida, it's no different when they're offering you a breath test after a legal arrest for DUI. They're saying, I'm now requesting a test of your breath. If the person says no, they then proceed to inform that individual that their license will be suspended for 12 months if it's the first refusal, or 18 months if it's a second or subsequent refusal. That is known as the Florida implied consent law. Now, in Florida, you're only charged with an additional misdemeanor for violating the implied consent law if it's your second or subsequent refusal. All accounts and reports on the Jay Cutler situation make it assumed that he is being charged with an implied consent violation simply for refusing the field sobriety or the sobriety test required by law at that DUI scene. He's also charged with possessing a firearm while impaired. Florida has a very similar statute, which happens to be a misdemeanor. If you are determined to be under the influence to the extent that your normal faculties are impaired, and that impairment could be as a result of alcohol or chemical or controlled substances, you could be charged with an additional misdemeanor if the officer determines that while you're impaired or in that state of impairment, you also possessed a firearm. Tennessee is no different. They seem to have a statute or a law very similar to the one in Florida, and Cutler was hit with that one. The last thing that's coming out of this whole Jay Cutler situation, which is probably the most concerning, and for his lawyers, it's going to make it the most difficult when it comes to negotiating and resolving this case for Mr. Cutler, is that he allegedly tried to bribe or offer the other driver with whom he was involved in an accident some type of monetary payment in order for them to kind of just handle it amongst themselves and leave the scene, assuming because Cutler knew he had been drinking, and once the cops arrived on the scene, this could escalate much further. However, once that other motorist told Mr. Cutler that no, he wasn't going to accept the payment and he'd rather wait for the cops to show up, the reports are that Cutler then tried to flee. So let's talk about that, because that's pretty important. Yes, in hindsight, had Cutler resolved that with the other driver and left the scene, we're probably not having this conversation. He probably doesn't get arrested for DUI. But in making that attempt, having it be rejected, and then trying to flee the scene as is being reported is a horrible fact. And it's going to make his defense attorney's job that much more difficult. Remember, if you're involved in an accident in Florida, under Florida law, you are supposed to report the accident or at the very least exchange information. So if the other driver wishes to call the police rather than exchange information on the scene, you are supposed to remain on the scene. Leaving the scene will bring about an additional charge for leaving the scene of an accident. That's typically a misdemeanor in Florida if there's serious bodily injury or death. The penalties and the severity of that crime will continue to go up into felony land and even include minimum mandatory jail sentences. So if you're involved in an accident, if the other driver does not want to resolve it and exchange information on the scene, unfortunately, you do have to remain and wait for the cops to come so they can do all the proper reporting. Obviously, I'm going to address the elephant in the room. If you successfully flee the scene of an accident while illegal, you could in theory be mitigating your consequences, but that's not advisable because too many things have to happen and work out in your favor in order to successfully flee the scene of an accident and avoid the DUI. Remember, they're still going to hit you with the crime of leaving the scene. If they catch you quickly enough, you're now leaving the scene of an accident with a DUI component. You just took your charge from being this serious to this serious. If you're involved in an accident, as unpleasant as it may seem at the time, remain, deal with it. If you happen to get arrested for DUI, do not speak, do not agree to perform field sobriety exercises or take a breath test. Usually that's only giving the government evidence to use against you. Be polite, be courteous, handle the stop as smoothly as possible. Post your bond, call an experienced DUI attorney who can try to get you out of the mess.